controversy. We are honored to have Justice Goldstone here today to present this memorial lecture. He will speak on the topic International Law and Human Rights, the Search for Justice. Justice Goldstone.
Provost Breslauer, the Director of the Institute, Mr. Chiba, my long-standing friend, Frank Chrysler, and I'm very happy that we have the Swedish Consul General Barbara Osher also with us this evening. And good afternoon or good evening to all of you. It's a great privilege to be back at Berkeley. The first time I ever taught, because I'm not a teacher by training, was in fact a short course I was talked into giving at Berkeley some 20 years ago. And it's almost 20 years since I was first interviewed by Mr. Chrysler on his now famous interview sessions. And I understand from him I'm one of few who've done it twice. And I hope one day to be the first to do it 3 times. The topic that I was asked to address this evening is international law and human rights, the search for justice. And what I want to do is to really take you briefly through the development, and it's fairly short development because these are new areas of international law, but the development of really a twin track. Firstly, the development of international human rights law, and on the other side, the development of international humanitarian law, which is the law that applies to armed conflicts, what used in the old days to be called the law of war. Now, both tracks have their origin, certainly in modern legal terms, have their origin with the Nuremberg trials of the Nazi leaders in 1945. Of course, Nuremberg was not an international court. It was a multinational court set up by the 4 victorious powers, and the four groups of judges. There was a judge and an alternate judge from each of the 4 victorious powers, and they came together to give judgment at Nuremberg. But until then, there was no recognition of any criminal sanctions, of any criminal consequences to violations of the laws relating to armed conflict. And until then, too, on the other track, there was little recognition or respect for human rights because they were really in the domain of the domestic courts of a very few countries where they were relevant. So let me sketch briefly these 2 tracks, and I'll begin with international human rights law. The birth of the United Nations was the beginning of the end of the colonial era, both in Asia and in Africa. This is best reflected, in fact, by the membership of the United Nations. It's interesting to recall that in 1945 there were 51 members of the United Nations. Today there are 182 members of the United Nations. So the number of independent countries rose more or less from 51 to 192 in a little more than half a century, 60 years or so. Now, at that time, there was a convergence of, firstly, a growing desire by the colonial powers to divest themselves of what had become a millstone around their neck, colonialism. And there was a growing unrest fermented by liberation movements and increasing demands for independence from the colonies. One of the consequences of the seismic anti-colonial movement was the birth and rapid growth of the civil rights movement, both in the United States, in North America, and in Western Europe. It all began with the unanimous adoption in 1948 with the Universal Declaration of Human Rights by the General Assembly of the United Nations, And of course, in America, it is well known that the critical seminal role in bringing that about, the Universal Declaration of Human Rights, was Eleanor Roosevelt. We must recognize, however, that the wide support for the Universal Declaration of Human Rights, and there were very few nations that voted against it. Two of the very few were, in fact, the Soviet Union and my own country, South Africa, both for obvious reasons. But the support that there was would have disappeared had the Universal Declaration purported to make law. It was a declaration, it was an aspiration, and that got a lot of the countries on board who would otherwise have been too embarrassed, even if it was politically impossible, to approve the Universal Declaration during the lifetime and activities of colonial governments. One of the first targets in the United Nations of these of human rights violations was again South Africa. It was the Indian representative in the late 40s who raised the discrimination practiced against Indian South Africans in the General Assembly. It gained little traction. There was no great interest in fighting racism in the middle of the century. The Western nations, of course, had too many skeletons in their own cupboard, and in fact out of the cupboard, to be involved. A country like Australia had its own whites-only immigration policy. The United States still had its Uncle Tom laws, and the civil rights movement hadn't really gotten to full swing. And of course, Britain, France, Belgium, and Portugal were running pretty awful colonies where the civil rights of the local people were pretty much at best ignored, at worst trodden on. But the civil rights movement and the ending of colonialism grew apace and began to unravel. And then in the 1960s, the Civil Rights Conventions emerged. What in 1948 was simply a declaration of human rights in the 1960s became binding United Nations conventions, and countries that signed on to them bound themselves to respect the rights in those conventions. Political rights, civil rights, cultural rights, and so forth. They were followed by other conventions, outlawing gender discrimination and various other forms of irrational conduct. And they were, of course, the direct result. It was the legacy of the Universal Declaration, which itself was the legacy of Nuremberg. So one sees this historical and impressive family, really, of rights. Domestic and international human rights organisations were born and flourished. Over recent years, they've exerted more and more pressure on governments to recognise and respect human rights. Whether one agrees with their terms or the manner in which human rights organisations name and shame nations who have not lived up to their human rights obligations, they remain today an influential voice, and one sees references to them literally daily in the media. Let me leave international human rights and turn to the law of armed conflict. Their growth has matched the significance and speed associated with international human rights. This development is the most important single legacy of Nuremberg. Immediately after the trial, which was considered to be sufficiently successful, there were calls for a permanent international criminal court. As far back as 1948, if you look at the Genocide Convention of 1948, a convention that's been ratified by an overwhelming number of members of the United Nations, in the Genocide Convention there's an assumption in Article 6 that there would be an international criminal court having jurisdiction. And there is another reference to such a permanent international criminal court in a 1973 convention that declared apartheid in my own country, South Africa, to be a crime against humanity. That also assumed that there would be a court with jurisdiction to try people guilty of the crime of apartheid. Notwithstanding the failure to create such a court, the laws of war nevertheless kept being refined and developed. And it's really quite remarkable, and much to the credit of the International Committee of the Red Cross, that this is so. They were really the guardians of the Geneva Conventions, of the Hague Conventions, and even though those laws were honoured in the breach, and there were no courts anywhere in the world that implemented them, they kept updating them and discussing them and calling conferences and generally getting respect for them. And I really do admire the persistence and the vision that got people to do that. The result was that in 1993, when to the great surprise of international lawyers, the United Nations Security Council set up the Yugoslavia Tribunal, and in the following year, 1994, the Rwanda Tribunal, there were international laws of armed conflict that were there for judges now to use for the very first time. War crimes are essentially committed where civilians and others who are not combatants are targeted, killed and injured. That's the main purpose of the laws relating to armed conflict. They're designed to protect to the extent possible and to the extent consistent with military justification to protect the lives of innocent civilians who get caught up in war. Now, during the 20th century, which was really a very bloody century, the bloodiest century in human history, the number of war crimes and the number of civilians killed and injured grew exponentially. According to Mary Kaldor, professor at the London School of Economics, at the beginning of the 20th century, the ratio of civilians to military casualties was about 85 to 90%. That means that for every civilian casualty, there were 8 to 9 military casualties. One civilian, 8 to 9 soldiers killed or injured in World War I. In World War II, that became 1 to 1. And that's hardly surprising when one thinks of attacks on urban cities, on urban centres, both by the Allied bombers and, of course, by the Nazi bombers who levelled Coventry and caused such terrible mayhem in London and other cities. So it became 1 to 1. During the past 30 years, and it's mainly been civil wars, internal wars, the number has grown to 1 to 9. One soldier killed or injured for every 9 civilians killed or injured. So what began as 1 to 9, more or less, one way at the beginning of the century, was completely put on its head by the end of the century. The absence of the implementation of international humanitarian law, of the laws of armed conflict, was really meant that there was complete impunity for people responsible for the commission of these war crimes. And it was in that context that the United Nations Security Council established the 2 ad hoc tribunals, as they're called, one for the former Yugoslavia and one for Rwanda. And for the very first time since Nuremberg, the laws of armed conflict were actually applied by a court. The result was the rapid growth and development of the norms. The one perhaps that it should be most proud of, and certainly I feel a great deal of pride in it, is the tremendous advance that there was because of the work of these courts in the laws relating to gender crimes. Systematic mass rape as a war crime was just about ignored by the laws of war. They were written by men for men, and rape, like plunder, was simply taken as a given. What wasn't taken into account in those laws was the intentional use of systematic mass rape, and it's been done over centuries, and it was ignored. And that, of course, was changed by the work predominantly of women judges who were appointed to both the Yugoslavia and the Rwanda Tribunal. And the result is, if you look at the statute, at the Rome Statute that now governs the International Criminal Court, you will see that gender crimes are very fully fully defined and fully developed. And that was an important benefit and an important success of the ad hoc tribunals, and that's going to be carried forward and is already being carried forward by the International Criminal Court. The successes, and there's no time to discuss them now, and there were problems too, and one shouldn't ignore them, but the successes were sufficient to move forward the endeavour to set up a permanent International Criminal Court. And that was agreed at the Rome Conference in the middle of 1998. 60 ratifications came in very quickly within less than 4 years by April of 2002, and the International Criminal Court's jurisdiction opened on the 1st of July of 2002. Today, 114 nations support the Rome Treaty, have ratified the Rome Treaty, and are members of the governing body of the International Criminal Court that's known as the Assembly of States Parties. So there's been a very rapid growth. Historically speaking, in roughly half a century, one's gone almost from nothing to a very sophisticated, advanced system of international criminal law today. And it applies not only in the criminal field, but also in the commercial field. The World Trade Organization has an appellate court that's rulings are considered binding by many countries, including the United States. Today, international humanitarian law, the law of armed conflict, and international human rights law really act together. The World Court, the International Court of Justice, has said in a recent opinion that in times of war, both of these laws apply, but the law of armed conflict, humanitarian law, as the special law, as the lex specialis, as it's known technically, takes precedent. But they're both there. In a broad sense, all of these diverse developments are essentially a search for justice, as the name of this evening's talk indicates. Social justice for those who suffered from severe forms of racial discrimination and colonialism, domination on the one hand, and justice for the victims who suffered the consequences of the commission of horrendous war crimes. What have been the important consequences of these two parallel movements that have really today come more and more together? Both of them have had successes and failures. Both of them have encountered hurdles and will in the future encounter hurdles, and especially from some powerful nations that have a natural suspicion of any international oversight. The powerful don't like to be looked at and judged. The smaller nations don't mind because they see in it some form of protection. On the positive side, international human rights have become an essential part of international discourse. There are the United Nations committees and many regional committees that receive reports from governments and name and shame those who violate the fundamental rights of their citizens and others subject to their control. It was that international human rights movement that played such a significant role in bringing down apartheid in South Africa. It was that international human rights movement that resulted in a proliferation of truth and reconciliation commissions and helped reconciliation in very fraught situations. It is that international human rights movement that has made it almost axiomatic that there should be international oversight of elections in countries where there might be questionable electoral practices or procedures. In the consideration of loans from the World Bank to developing countries, the human rights record of the applicant nations are now routinely taken into account. I'm sure that many other examples will occur to you sitting in the audience. In the result, we have two types of regimes. Generally speaking, we've got those democracies that take the human rights of their own people seriously and who welcome human rights organizations, and on the other side we have only too many oppressive societies where human rights are consistently and frequently violated and whose leaders resist and criticize the human rights community when they name and shame them. They are unfortunately aided by the double standards that have unfortunately become a feature of the United Nations system and some of its organs. You know, there were double standards at the very birth of the United Nations. It was double standards to have permanent members of the Security Council with a veto power. It was a double standard then, and it's become even more of a double standard. Why France and why the United Kingdom and why not Germany and why not Japan? And why not a single country on the African or the South American continent? So it was there at the very birth that there was an unevenness in the democratic principles that were foundational to the United Nations. But it's got worse. There are double standards with regard to the attention lavished on some violators of human rights and not others, and so too violators of the laws of armed conflict. Why did the United Nations Security Council effectively ignore, from the point of view of setting up war crimes tribunals, ignored Saddam Hussein, who committed the most terrible war crimes against his own people, and Pol Pot, who killed some millions of his people in Cambodia? Yet it was the former Yugoslavia that first got the attention, and I think we can accept that the reason for that was it happened in Europe. If Rwanda had happened first, there wouldn't have been an international war crimes tribunal for Rwanda. There was one for Rwanda because the precedent had been set for Europe. If it had been done for Europe, it was hardly open to the United Nations to say, well, we're not going to do one when it's requested by an African state who to boot happened to be at that time a non-permanent member of the Security Council. Why a fact-finding mission for the Israeli attacks on Lebanon and Gaza and not for Sri Lanka? Why no fact-finding mission for the war in Chechnya? In a fair world, similar situations should be treated in similar ways. That said, even with all of this ambivalence, it cannot be appropriate, I would suggest, to object to investigations in situations that cry out for inquiry. I don't believe it lies in the mouth of countries who are targeted for inquiry to say, don't look at us. What they should be saying, look at us, but look at the others as well. That's a different approach. I mean, if one's looking at even-handedness, it does. If there are 14 murders committed in New York City today, and the police apprehend 3, it doesn't lie in the mouth of the 3 to say, look, it's not fair to put us on trial. The other 9 got away with it. The answer is to have more efficient policing and to have everybody treated and tried in the same way. The argument that one shouldn't be investigated if not everybody is investigated, of course, was the cry for many years made by the South African apartheid government, and particularly in the latter days of apartheid. Those rulers said that if the United Nations refused to criticize all human rights violators, they had no right to criticize the racist policies of South Africa. Those arguments were, fortunately and correctly, of no avail. The victims in Lebanon or Gaza, the victims of thousands of rocket and mortar attacks in southern Israel, are entitled to the acknowledgement that comes from efficient and credible investigations and the trials of those who appear to be responsible. The failure by the United Nations to investigate other or even worse violations does not in any way weaken the rights of any of the victims. It is, of course, shameful that the rights of some victims are completely ignored. It was my hope, and it may have been naive, certainly in retrospect, but it was my hope that an even-handed investigation into the events relating to the 2008-2009 Gaza war would garner the cooperation of all sides, and especially from Israel. It was also my hope that the inquiry into all aspects of the Gaza war would begin a new era of even-handedness in the Human Rights Council. This was, after all, the first time, I repeat, this was the first time that the United Nations was looking into illegal acts of terror from Gaza militants who were, as I say, firing thousands of rockets into southern Israel. It is to my lasting regret that those developments did not materialize. To the contrary. I suggest that we should not give up the quest for international justice and that we should pursue it to the best of our ability. A word about Sri Lanka, unfortunately too much ignored, and too much ignored by the Human Rights Council. In May 2010, there were reports, credible reports from the International Crisis Group, to the effect that the Sri Lankan government's security forces and the Liberation Tigers of Tamil Elam, the LTTE, had both committed on each side serious war crimes during the last months of their 30-year bloody civil war. The evidence indicated that tens of thousands of Tamil civilians, men, women and children, were killed. Hundreds of thousands were wounded. Many more were deprived of adequate food and medical supplies, and this resulted in yet more deaths. The security forces, the government forces, shelled hospitals and makeshift medical centres with full knowledge of their precise locations and functions. During the time of these incidents, the government was informed of the consequences of their actions. They were informed by the United Nations, they were informed by the International Committee of the Red Cross and other humanitarian organisations, all to no avail. Similarly, the government forces repeatedly shelled humanitarian operations and these distribution centres. Many children, women and men were killed. The LTE, the rebels, fired on and killed or wounded many civilians in the conflict zone who were attempting to flee. It is likely that in Sri Lanka, the government and the LTE military leaders are responsible for the commission of the most serious crimes. Domestic and international human rights groups have called repeatedly for the United Nations to set up a fact-finding mission into those allegations. The High Commissioner for Human Rights, my fellow country person, Navi Pillay, requested the Human Rights Council to establish such a mission, and this was after the report on Gaza had been submitted. To their shame, a majority of the Human Rights Council refused to establish such a mission. They followed the wish of the Sri Lankan government that this was an internal matter and wasn't a matter for the Human Rights Council. China, India and Egypt joined 26 other nations in coming to that shameful conclusion. This indefensible action by the Human Rights Council fueled the long-standing and repeated complaints by Israel that the Human Rights Council and the United Nations in general was biased against it. It renewed the complaint that those bodies repeatedly rushed to pass condemnatory resolutions in the face of alleged violations of human rights law by Israel, but failed to take similar action in the face of even more serious violations by other states. Until the adoption of the Gaza report by the General Assembly and the Human Rights Council and the European Parliament, those organisations had failed to condemn the firing of rockets and mortars at Israeli civilian centres. This was the first time, in consequence of the Gaza fact-finding mission, that those actions were condemned by any of those important bodies. Sadly, but notwithstanding the best efforts of the United States and other Western nations who serve on the Council, as I say, it failed to act in the case of Sri Lanka. The Secretary-General Ban Ki-moon has not let the matter rest. He has set up his own advisory panel to advise him on what steps should be taken to bring about accountability in Sri Lanka. That report is expected any day now. Could well be today or tomorrow and certainly next week, and it's certainly my hope, and I hope it's not being over-optimistic, my expectation that some fact-finding mission will be set up, not by the Human Rights Council, but by the Secretary-General, who has the power to do that. The resolve of the Human Rights Council is again and will continue to be tested with regard to the serious allegations coming out of Burma. I wish I could feel optimistic as to its response. But again, I stress, the answer is not to give up the endeavour of enforcing the international human rights laws and international humanitarian law. Apart from the immorality of doing that, the consequence would be to give a free pass to those who commit the most atrocious and egregious war crimes and human rights violations. In conclusion, that is the challenge facing the international community, and especially organs of the United Nations. It is also, of course, the challenge facing the United States of America, that with every justification prides itself as being the leader of the free and democratic world. Thank you.
You want to sit down when we answer questions? Yeah. So if you have a question, put it on a card. No speeches, just simple questions. They can be complex, but simply worded. And we'll collect the cards. And as they're coming up, I will go through them. And I will take the liberty of asking the first question. Justice Goldstone, are there any lessons from South Africa that you think we should consider as we watch events today in the Middle East, where movements for democracy have, at least in the case of Egypt, overthrown the ruler?
You know, I think one must be careful about comparing apples with pears. I think each situation is different. It has its own history, it has its own symptoms, and I think it's very dangerous to draw parallels. But lessons can be learned. I think the one lesson that any country facing difficult situations can learn from South Africa is that in the depths of despair, hope should never die, that one never knows what's going to happen tomorrow. I think that's one lesson, because certainly, speaking for myself, and I can speak for the overwhelming majority of South Africans, black and white, until 1990, the prospects of a reasonably peaceful, negotiated transfer of power from a white oppressive minority to a democratic majority seemed out of the question. Nobody anticipated it would happen. And if that's a lesson, I think it's an important one, that there should never be, one should never give up hope. I think a second lesson from South Africa is the importance of leadership. And it will be important, I think, with regard to Egypt in particular, to see what leadership emerges from the present situation. Because what's really been unusual with regard to Egypt is that it's been from the bottom up, not from the top down. And it really, I would suggest, much to the credit of the people of Egypt, that they did it. That they did it peacefully, and they did it with a tremendous amount of dignity, which doesn't always happen. And I think not enough has been said to credit them. But what they need now is leadership that they deserve, leadership that will bring about true democracy. And democracy, let me say, and it's obvious, democracy doesn't mean having elections. Adolf Hitler was brought to power through elections, and so was Mugabe in my part of the world, and so was Milosevic. What democracy needs is a culture of democracy. People have to understand it, and there have to be respect. There has to be respect for all people living in the country. And certainly in the last 16 years, South Africa has moved pretty far along that democratic path. We have a Bill of Rights, we have a court, the laws are implemented, the laws are respected by the government and the people. And let us hope that that will be the path that's adopted by former oppressive societies, whether in the Middle East or elsewhere.
There are a number of questions here that raise questions about the role of a lawyer and a judge under the apartheid system. I guess what would be of interest to the audience is, how does someone who is a practitioner in a legal system work at the margins to change that system over time?
Well, the question's often asked. I was a student leader very involved in the anti-apartheid movement, organizing marches and demonstrations and losing my passport for some years as the form of punishment that was imposed at that time in the early 60s by the apartheid government. How did I come to be appointed to the apartheid judiciary? Well, the reason really is an American reason. The United States of America, mainly through foundations, and it was mainly Ford and Carnegie and some others, that organized in 1979 a human rights conference in Cape Town, the University of Cape Town. Now, in 1979, the word human rights was a swear word in the lexicon of white South Africans. Human rights were synonymous with communism. If you espoused human rights, you were at least a fellow traveler, if not a full-blooded communist. And black people who espoused human rights often were put in prison for it. Some whites were too, for that matter. So to have a human rights conference in Cape Town was something quite startling. A few judges at that time, including particularly Michael Corbett, who became the last apartheid Chief Justice, who swore in Nelson Mandela as our first democratic president, called for a Bill of Rights at that conference. And that took tremendous courage for a judge who was then in our highest court. From the middle 70s into the 80s, the apartheid government liked to boast of their independent judiciary. They had an independent bench. And it was difficult for them to make that boast if they were seen only to be appointing pro-apartheid leading lawyers to the bench. And they decided that they could afford to appoint some liberal anti-apartheid lawyers to the bench. My role model was a judge who joined me on the Constitutional Court, who unfortunately died soon after his appointment, John Didcot. He was the first of the anti-apartheid judges to accept an appointment, mainly because as a result of the Cape Town Conference, organizations were formed, and particularly the Legal Resources Center, based on the Legal Defense the Legal Defense Fund of the NAACP here. Professor Jack Greenberg, then the director of the Legal Defense Fund, came and helped South Africa set up the Legal Resources Center. They started using the courts to establish the rights for black South Africans. The provost mentioned the case of the Group Areas Act. That was a case that was dreamt up by the Legal Resources Center. And some of us who were opposed to apartheid were encouraged by leaders of the human rights movement to take appointments. They said, if we're going to bring those sorts of cases to court, we would like to have sympathetic judges, not unsympathetic judges. And if your conscience allows you to do it, and that wasn't an easy question, because what made it all the more difficult, certainly for me, was that by accepting an appointment, I was helping to lend legitimacy to the claim of the government that it had an independent judiciary. It was a question of trade-offs. Looking back, if I lived my life again, I would have taken that decision because it did enable me to play a role in the transition that little did we know was going to be around the corner. But the Legal Resources Center brought cases that were heard by sympathetic judges that really blunted some of the worst edges of the apartheid system to the benefit of many millions of black South Africans. So there are two ways of looking at it, I think. One has to take these decisions and live with them. But the government could afford to do this for two reasons, to appoint liberal judges. Liberal in South African terms. I believe liberal has become a sort of swear word in many sectors in the United States, but in South Africa I'm using it really as synonymous for anti-apartheid and anti-racism and anti-discrimination. The government could afford to appoint a few of us for two reasons. A, the majority of the judges, 90%, were fully supportive of apartheid. And they didn't need to get midnight calls. They were very quick to do and to uphold the apartheid laws. A. B, we had no constitution, so the judges had no power of judicial review. What Parliament said was the law, no matter how unfair, no matter how racist, no matter how oppressive. So what some judges might say on Monday, if the government didn't like it, the government could undo by passing legislation on Tuesday. It became more difficult because of the anti-apartheid movement, because of sanctions. The government became more and more keen to blame judges for what was happening than to accept the political obligations and so on.
There are a number of questions here about the enforcement of the verdicts of courts, the insights of commissions. What are your thoughts about that? I know as the prosecutor in Rwanda and the Bosnia tribunals, you were very frustrated by the inability to get the allies to cooperate in making arrests. But it's a general problem. So in your work, you are raising the bar for the standards for international law, but then the bar is somehow lowered when there isn't enforcement in some cases.
Well, of course, you know, I for the last 2 years have been teaching courses at American law schools on international criminal law and on the tribunals in particular, on the ad hoc tribunals, on the International Criminal Court. And I tell my students at every class, if you don't understand the politics of international justice, you don't understand international justice. It's all about politics, for good or bad. But you know, I've forgotten who it was who said very wisely, he said, a problem without a solution isn't a problem, it's a fact. And I think there's a lot to that. One of the so-called problems of international justice is the lack of enforcement and the difficulty in getting the government of the Sudan to arrest its own president and other leaders and hand them over for trial in The Hague. People laughed when I said the same thing about Milosevic. Who's going to arrest Milosevic as long as he stays home in Belgrade? And Milosevic, unlike many leaders, was happy to have his holidays at home and happy to use hospitals in Serbia. Other leaders have got into trouble because they prefer going abroad for their holidays and going to better clinics in Germany and elsewhere when they get ill. But who would have thought? Milosevic wasn't concerned for a minute about being arrested and being sent to The Hague. When he was indicted by my successor, Louise Arbour, during the peace negotiations that were being conducted on behalf of the UN and the EU, Milosevic never referred at all to the indictment out against him in The Hague for genocide. He never thought for a moment he would be arrested and sent for trial. Little did he know that a few months down the road, there'd be a popular revolution in Belgrade, that his government would be overthrown, and that his successor, President Djindjic, would bundle him onto an aeroplane and send him to The Hague. But that's the political happenstance that there has to be. And until governments more and more cooperate with the International Criminal Court, it's going to face these problems. There are two situations at the moment where trials are going on for the Democratic Republic of the Congo and the Central African Republic. Both situations referred by those governments to the International Criminal Court, and people have been arrested and trials have begun. In the case of Uganda, the Ugandan government hasn't got the political will to arrest Joseph Kony and the leaders of the Lord Resistance Army, who have chopped off limbs and used child soldiers and committed the most awful crimes. So it's a question of political will. Whether another government will change and do it, I don't know. But what I do know is that the prosecutors and the judges must do their job. They must investigate, and if the evidence establishes that crimes were committed, they must request arrest warrants to be issued by the judges, and they must pressure, and the good governments around the world must press for the arrests. And it's certainly my hope that even though the United States is reluctant and remains reluctant to ratify the Rome Treaty, more and more, beginning with the last years of the President George W. Bush administration, the United States is working more and more closely with the International Criminal Court and encouraging it and helping it in those cases that are consistent with the foreign policy of the United States. And that's important, because certainly from my own experience, without United States support, the Yugoslavia Tribunal, the Rwanda Tribunal would never have got off their feet.
There's a question here. Do you find evolving norms more powerful than sanctions in international human rights law?
Sorry, did you repeat that?
Do you find evolving norms more powerful than sanctions? How do you see the two related?
You know, sanctions haven't a very happy history. Apart from South Africa, I don't know of any other situation where sanctions have had any success. And even in the South African case, they were only part of the story. Sanctions made a difference, but they made a difference because of violence, internal violence. They made a difference because South Africa had become a pariah state. I can tell you there was nothing worse than travelling the world with a South African passport. I knew when I handed my passport to a passport official, whether in New York or in Hong Kong or wherever I went, I'd get some lousy, caustic remark about South Africa. And my reaction would normally be to say, I understand why you're treating me like this, I don't blame you. Of course, I couldn't say that and wouldn't say that. But sanctions are not an efficient tool. And if it was only sanctions, apartheid wouldn't have been brought down. It was many other things. And of course, sanctions in South Africa were different for one reason. The majority of black South Africans who were the main sufferers of sanctions. I mean, sanctions didn't really bite wealthy white South Africans. Who did sanctions hurt? They hurt the poorest of the poor in South Africa because they affected employment and so on. But in South Africa, it was those people, it was the leaders of the black oppressed majority who called for the sanctions. And that made a huge moral difference. But I don't believe that there's any emerging norm. The sanctions that were imposed on Saddam Hussein failed abysmally. The only people who benefited from the oil for food sanctions were the crooks, were the people who bribed and got illegal money, as we established conclusively in the oil for food inquiry that was set up by Kofi Annan. So sanctions really, I understand. You know, when people feel helpless and hopeless, it may be that anything is better than nothing. And it may be that sanctions helped in South Africa, and whether they can help in other situations, I think is very difficult to say.
There are a number of questions here on the Gaza report and on both sides. Some get into particulars and so on, but before we look at some of them, let me ask you a general question. What did you hope that mission would accomplish? You touched on it in your speech, but let's talk a little more about that. And in the context of what you hope to achieve, what were your biggest disappointments?
Well, clearly what I hope to achieve is what any fact-finding mission should hope to achieve, and that is to establish facts. That's what a fact-finding mission is set up to do. And you establish facts by investigating, by having a look, by talking to people, by looking at the evidence, by getting satellite reports and whatever. Clearly, in order to do a job more fully, more complete, you can never do a perfect job, obviously. And especially in the circumstances in which we worked, there were financial constraints, there were time constraints. We were given 3 months to run the fact-finding mission. But it was certainly my hope, and I set it out very fully in 3 letters that I sent to the Israeli government. The first one, the day I was appointed, a letter to the Israeli ambassador to Geneva, followed up with a second letter to the Israeli ambassador in Geneva, and finally a personal letter which I addressed to Prime Minister Netanyahu. I really pleaded for them to meet with me, and I said I'm prepared to come at short notice to Jerusalem. I pleaded with them to meet with me to tell me how they wished the mission to go about its work, who we were to see, where we were to go, what we were to do. And I really thought, as I mentioned in my remarks earlier, I really had nurtured the deep hope and expectation that the Israeli government would take this opportunity for the first time of having an international UN platform to put its version to the public and to the international community. It didn't. We had to find facts from Israel in other ways by getting some people, including, to his credit, the mayor of Ashkelon, who came and spoke to us in Geneva. We had our staff make something like 50 personal telephone calls to victims in Sderot and other towns in southern Israel to get evidence of what they were going through and what they suffered. And Israeli organizations, human rights organizations, also assisted in giving us information. So really, the hope was a very simple one, and that was to establish the facts on which investigations, proper investigations, could be launched to ascertain whether war crimes were committed, who was responsible, and to bring appropriate proceedings if that was done. Israel has, I think to the credit of the Israel Defense Force, did launch a number of investigations. Some of them have been made known, others haven't. I regret that the evidence has not been made known. It was all these investigations were held behind closed doors, which I understand the reason, but it's unfortunate. But even then, some of the conclusions which have been made public have confirmed some of the facts referred to in the Gaza report, and in particular the worst of the incidents we reported, the bombing of the home of the Al-Samuni family, which resulted in the deaths of 29 members of one family, a family that had been told to go to that house less than 24 hours before by the Israeli ground troops. That has been confirmed by the Israel Defense Force. They have said that the commander who gave the order to bomb the Al-Samuni home is being questioned because there's evidence that he was aware that there were civilians in that home. What the result will be, I don't know, but this is at least some important action being taken in at least some sort of democratic way. And if one compares that to the other side, we called on both sides to investigate the allegations of war crimes. Hamas, perhaps not unexpectedly, but the fact is that they have not responded at all. There has been no attempt on the part of Hamas or any other militant groups to investigate at all. Let me say, too, that I personally requested that we should be allowed to meet on our visits to Gaza, that we should be allowed to meet with the militant groups. I wanted to find out how they justified the firing of mortars and rockets into civilian areas. And they came back to us 24 hours later and said no such meeting can be arranged. So one had problems on both sides. And all we could do was our best. I can tell you it was a very emotional, disturbing nightmare to go to Gaza in the aftermath of that war and see at first hand and to speak at first hand to members of families whose loved ones had been killed, and I'm talking about civilians, I'm talking about children, I'm talking about women. It was awful to see some of the thousands of houses that had been completely destroyed, over 5,000 of them. And of course, because of the lack of building material that was being allowed into Gaza, the sites we saw was pretty much the position that it was on the last day of the war. And I really challenge anybody to go and witness that, to see the number of people hobbling around on crutches, people who were injured in that war. I really challenge anybody to go there, even now, nearly 2 years after the war, and not be personally moved by that witness.
In approaching the fact-finding mission, what are the problems of dealing with what you call the politics of international justice and the history of that conflict? It's not as if you're, this is an episode of a crime thriller in which you can go and find the facts, but those facts are embedded in a history of conflict. What are your thoughts about that? Because a number of the questions find fault with the Commission based, I think, not just on what they found, but on their misunderstanding of the broader politics.
Well, of course, let me say, firstly, the mission accepted and proceeded on the basis that Israel has a right of self-defense. It has not only a right but a duty to defend its own citizens against rocket attacks and so on, and they could have, the consequences, it was really happenstance, luck, if you're religious, God's will, that the number of Israelis killed and injured wasn't a great deal higher. If more of those rockets had landed on kindergartens and the very recent attack in the last 2 or 3 weeks, where a wedding party was just missed, the consequences really could have been quite horrendous. And the fact-finding mission looked at what was done during Operation Cast Lead in light of the acceptance that it was proportionality and justification, a military justification that we were looking at. We could have investigated hundreds, if not thousands, of specific incidents and allegations. We couldn't. We had a staff of 17 people. Many of them had been employed from around the world, some highly trained investigators from many countries. And we were ultimately given a list of some hundreds of incidents. And the 4 members of our mission took the decision that we were going to investigate those incidents that were where there hadn't been military force used in the heat of battle. It's very difficult to sit in an armchair and criticize a soldier on the ground for firing in self-defense. If the soldier makes a mistake, one can only understand it and sympathize. We were looking at situations like the Al-Samuni, like the bombing of a flour factory, which seemed to be divorced from the heat of battle, because we didn't want to second-guess people in the field who were operating under the stress of battle. And those were the incidents. Of course, there were many situations, I've no doubt, that could have been investigated with a different consequence. There were many incidents where it would have been more difficult to come to any conclusion without having the other side. And even having the other side, let me deal with the Al-Samuni case. The evidence we were given was that the Israeli ground troops wanted to commandeer the home of one of the homes of the extended Al-Samuni family. It's a large family living in a semi-rural area outside Gaza City. And the Israeli army wanted that house because it was on a rise, and they wanted to set up their temporary headquarters there. War's a lousy thing, and they were entitled to do that. So they told the Samuni family to come out, and they said you can go and move into the other Al-Samuni home down the road, 75 yards away. And they rounded up some other Samuni family and put them all into that house. There were over 100 of them crowded into one house on day one. On the evening of day 2, It's cold. It was winter in Gaza. Four men on the Samuni home went and got firewood to light a fire. On their way back, they were fired on by helicopter gunships, and the Samuni house was bombed. As I say, 29 people were killed. Those were the facts we were given. What conclusion would you come to as regard to intention and as regard to wrongfulness on those facts? Israeli soldiers tell them to go there, they go there. They within eyesight of the Israeli soldiers. They regarded the soldiers being there as some sort of guarantee of their safety. The next night they bombed. Those are the facts. And we came to the conclusion that this, on the face of it, amounted to a war crime intentionally going against civilians. The reports that came out of Israel 2 months ago, now this is almost 18 months after the incident, hasn't been proved, but the story that was put out, and it may well be correct, the story that was put out was that a drone took a photograph of these men carrying firewood. It was a bad photograph, it was badly grained, and it was sent back to headquarters in Israel. It was interpreted wrongly that these men were carrying launchers, rocket launchers, and the order was given to bomb them and the house to which they were going. Now, I mean, that's the sort of information I would have liked to have had before the report was written. It's not an excuse, incidentally. It negatives intentional targeting of civilians, but it indicates a high level of negligence. It indicates a complete lack of communication between the man in Israel who makes the decision and the troops on the ground who told that family to go there. But that's the sort of thing that needs to be investigated. And it's a pity that in respect of many of the incidents that we did investigate, that we didn't have the assistance that I think we should have had. And then unfortunately some members of the cabinet in Israel at the time wanted to cooperate. I remember there were at least 2 cabinet ministers. I think Minister Meridor and Minister Herzog wanted to cooperate, but the majority, particularly led by the Minister of Defense Barak, said we're not prepared to cooperate under any circumstances.
In the post-9/11 world, where we've become quite aware of non-governmental actors, terrorist groups, who have entirely different standards of how they conduct war, that dilemma seems to be behind the arguments about what went on, because one could put on the table the argument that, and I use the word terrorist in quotes, whatever the groups are, but not state powers, use tactics that choose not to define the front, that choose not to define a soldier versus a civilian. That is the argument made on the other side, so that in your report, let me say it this way, what then do you do with this new context as you engage in these fact-finding missions? Because they raise important questions about what is going on beyond the facts.
Well, you know, let me separate the report from the question, because we, for the reason I mentioned, avoided dealing with situations that appeared to, we didn't investigate the justifications. We investigated situations where it appeared that crimes had been committed. And that was our job. But there is a difficulty, obviously, in fighting non-state actors. Call them terrorists, call them freedom fighters, call them whatever you wish. There is a difficulty because it's more difficult to protect, in some ways, it's more difficult to protect civilians. But the law remains the same. The law obliges armies, non-state actor armies or national armies, to protect civilians consistent with military justification. So if there's the example, if I can repeat it, I gave you during our interview this morning, if there are four militants on top of a building firing rockets into a civilian area, and there happen to be 3 or 4 or 6 civilians in that house, I don't believe it's a war crime to bomb that house and take out the rocket launchers. And if some civilian lives are cost, well, that's what happens in war. But if there are the same 4 militants firing rockets from a hospital roof in which there are 1,000 patients, civilian patients, I don't believe it's justified to bomb the hospital. There are going to be losses. There are going to be losses both ways, and that is what war is about. And I don't believe the example I've given would be disagreed. I don't think there'd be any disagreement on the part of any leader of the Israel Defense Force or any other army, because that's what the law of armed conflict demands. Often difficult, but those decisions have to be taken, and when judging them, one must be careful not to be an armchair critic. One must be careful to get as many facts and explanations as possible and to take a decision one way or the other on the basis of the facts.
Were you surprised by the ad hominem attacks that were generated by the report?
Well, obviously, ad hominem attacks, apart from being unpleasant, I mean, I glanced at the circular being sent out very bravely. I notice it's anonymous. But containing, I assure you, complete misstatements of fact. I could disprove, I think, just about everyone. But those sorts of attacks are very hurtful. They're hurtful not only to one personally, and I needn't explain that, but they're even more hurtful to members of one's family.
Mm-hmm. And what would you have liked for the result to be ideally of the Gaza report? I mean, undoubtedly you didn't think it was going to solve the overall political conflict, but what were your hopes?
Well, my hope was that there would be, as there has been previously, certainly on the Israeli side, a public inquiry into the allegations. If they could have been disproved, I would rejoice. I got no pleasure, believe me, in making the findings we made. But certainly in the case of Sabra and Shatila, there was an internal Israeli investigation which resulted in the forced dismissal of the then Minister of Defense, Ariel Sharon. And that was because the public clamored for an independent inquiry. And my friend Aaron Barak, the now retired president of the Israel Supreme Court, was one of the 3 leading members of that inquiry. But things have changed. The politics has changed, and it didn't have that effect. And it was simply thrown out, and the baby with the bathwater, and certainly resulted in attacking the messenger rather than looking at the facts. But it was with that hope that really I insisted that our main recommendation. What was the main recommendation of the Gaza report? It was calling on the parties to have their own internal investigations. That was our hope, that the allegations would be looked at by a credible public inquiry, and I have sufficient confidence in the Israeli legal system to know that there are more than enough qualified, retired judges, lawyers in Israel who were more than competent and certainly had integrity by any standards, who could have conducted such an investigation. That was certainly my hope. It hasn't happened, and it doesn't look like it's going to happen. On the other side, I was more skeptical. Groups like Hamas are less likely by far than from within Israeli society to have a similar investigation. But they could have too. There's no shortage of qualified lawyers in the Arab world with integrity whose views would be accepted. They could have done it. It's a matter of political will, and the political will was absent on both sides.
In both sides on this conflict, there are trajectories if the forces continue to go the way they are. On the Israeli side, some people say, well, if Israel doesn't do something about the Palestinian problem, you're going to have an apartheid state. On the other side, if things are not done with regard to Hamas and such organizations, the danger is that you will have a continuing terrorist organization terrorizing the people. What can international law and these processes do to move us away from these possible trajectories?
You know, Harry, I don't think it's a matter of international law. It's a matter of politics, and I'm really not a I'm not a politician. I'm happy to say, and you know, these are really extra legal issues. Let me say one thing: I don't like making the comparison between apartheid in South Africa and any situation that might arise in Israel. I think they're two very different systems. There may be some similarities, but there's many differences. I think it's unhelpful in the debate to make that comparison.
We'll make this the final question. What would you like to see the legacy of your work, both in Rwanda and the Bosnia tribunals and in fact-finding missions like you've undertaken in Gaza war, on terrorism, and on investigating Iraq and so on?
Well, clearly it's my hope that these inquiries, and going into them, I go into them because my hope is that they will help, that the truth can only help. It can hurt short term, but long term it can only help. I go into them because I feel that they can assist in reconciliation. I go into them because I think from a moral point of view, victims are entitled to public acknowledgement of what happened to them. They're entitled in their societies and even in the world to have the acknowledgement of what they've gone through. And if you ignore them, they're going to get angry and call for revenge. And this was the importance, I think, of the Truth and Reconciliation Commission in South Africa. It forced white South Africans to use Archbishop Tutu's expression, to look the devil in the eye, to accept what was done in their name, what was done for them, and they knew about it, but turned a blind eye and believed the fabricated denials and excuses that were given. So it seems to me that whether it's in Rwanda or the former Yugoslavia, and let me say I've just come back from a visit after 15 years absence from the former Yugoslavia. I spoke in Sarajevo, Zagreb, and in Belgrade, and I really felt tremendous pride. Let me be blunt. I felt pride in the reaction of people who came to hear me talk, of gratitude and a feeling that the false denials had stopped. There was still blame being, you know, why so many Serbs indicted? Why not more Croatians? There's still that sort of talk. But even that question carries with it an acceptance that we were guilty too. And I think that's important. I think when people, when there's criminality on behalf of a people, it's important that that be recognized. And I think it can often be a precondition for peace. And it's certainly my hope, and I hope it's not a vain one, and I hope I live to see the day where the fact-finding mission on Gaza will be judged by history to have assisted and not hampered any future peace in the Middle East.
Justice Goldstone, thank you for being here. Thank you very much. That was good. I thought, that was
That was a tough one.